This Honorable Court of Criminal Appeals of Tennessee is now in session.
Thank you, Supreme Court Clerk Jim Hevner, for your introduction today and your help in assuring that we can proceed with these Zoom arguments in lieu of in-person arguments, and trying our best to curb the spread of COVID, or doing our part in that. We also like to thank the AOC staff and the lawyers for participating in this. This is not the way we probably would like always to do it, but I believe my colleagues and I are about to agree this is a pretty good alternative if you had to have one. It's better than mailing an argument and us having to rely on your briefs all the time, although sometimes that works just fine. But we like for you to have the opportunity to be in front of us. I'm going to ask the clerk to go ahead and call the case, and then I will make some other announcements.
Lizandro Guevara versus State of Tennessee.
Thank you. The panel that will be hearing your case today, leastwise to my right, is Judge Bobby Holloway from Columbia, Tennessee. On my left, Judge Robert Wiedemeyer from Nashville, Tennessee. I'm John Everett Williams from Huntington, Tennessee. Each side is given 20 minutes, just as if we were in person. The appellant may reserve time for rebuttal upon introducing themselves to the court. And with that, we'll call upon the appellant to begin his argument. Your time starts now.
Thank you, Your Honor. I'm going to start my phone real quick. Yeah, my name is Jonathan Turner. I represent the petitioner, and I want to apologize first. This is my first Zoom hearing ever, and first one before the appellate court, so this is kind of new for me. But we're on here on appeal from a post-conviction case from Davidson County. Just briefly, some history. The petitioner was convicted in July by a jury of 2011 of 8 counts of aggravated battery, 4 counts of rape of a child. The sentence were entered in September 2011, basically giving him a life sentence with the amount of time that he was convicted for. At trial, the brief summary of what happened at trial, these allegations were between 2005 and 2009. When you look at the indictments are 3.5-year timelines. There's no specific dates, times, nothing even within a small time frame. The allegations occurred between the alleged victim and the petitioner because they lived together in 3 different houses. When the alleged victim was between 5 and 9, during the 3 houses, the victim testified that basically the petitioner sexually abused her and raped her on various occasions. Also, she ended up reporting this in 2009 after years of her testimony of the allegations. The authorities stepped in, ended up taking a swab for a DNA sample. The DNA sample came back where it's in the petitioner's parental lineage. One thing of note is that the petitioner's brother did live with him at the second house and was also in Nashville during that period of time, as he was actually present in 2009, specifically when the mother was addressing the alleged victim. When you look at the post-conviction hearing, the petitioner testified. Well, the petitioner testified at trial and denied all allegations, but at the post-conviction hearing, he testified again, and basically he alleged several things. One, that the trial counsel never interviewed or called any witnesses, which was true. No witnesses were called in a defense besides the defendant. Counsel was ineffective for employing a forensic psychologist, that he did not mount a credible defense strategy, that he in addition didn't communicate with the petitioner, and that the trial counsel did not file any pretrial motions, including the bill in particular, and that he didn't ask for a jury instruction on for a lesser included child abuse.
Were any of those witnesses called at the post-conviction relief hearing, or was
No.
a psychiatrist did they testify at the post-conviction relief?
No, Your Honor, there was no witnesses, and of course that's an issue in the case. But that kind of drives the point of point E of the. Well, first of all, that we're alleging the trial counsel was ineffective, and we'd have to prove we're in agreement with the state that the trial counsel was deficient and prejudicial. But when you go on number argument E, counsel was ineffective by failing to file a motion for a bill of particulars. In this case, is particularly troubling because the indictments were for a 3.5-year period of time. No bill of particulars was actually was attempted to narrow the time frame. And Rule 7C clearly, Tenet C Rules of Criminal Procedure provides for a bill of particular to adequately give to identify the crimes. And State v. Hicks of the Supreme Court, Tennessee Supreme Court in 1984 specifically ruled that when a judge did not grant a bill of particulars in a sexual abuse case that alleged about a year time frame, that that was an error, and they granted a new trial. And the reason why they said that was that there was no time or year associated with it that the counsel couldn't adequately defend. And in this case, when you look at it, there was a 3.5-year period of the allegations, and there was really no way for it to mount a credible defense when you don't even know when these things happen. They could have called witnesses that would have identified whether or not he was working during these period of times, whether the mother was at home, was anyone else home. But basically, there's really no way to defend an allegation of generic allegations for 3.5 years. We would submit that as the state has conceded that was deficient, but the state is arguing that it just wasn't prejudicial. Petitioner would argue that it has to be prejudicial because there's really no way to defend himself against allegations as generic as that. So we would submit that would be a grounds for a new trial, and we would refer to State v. Hicks. The other allegation that we would like to discuss real quick is D. Counsel was ineffective by failing to communicate with the petitioner. It's undisputed that the petitioner was offered a 10-year probationary sentence by the state, and trial counsel evidently went to the jail to communicate through his own testimony that, in fact, this offer was given. However, one thing that's not pointed out is that there was an interpreter at the trial and the post-conviction hearing for the petitioner. And trial counsel alleged that he wrote the offer on a pad, a yellow pad, and he didn't even mention whether it was in Spanish or whether the petitioner could understand it. And the trial counsel admitted that he was using another lawyer to help him with Spanish because he didn't really speak Spanish and the petitioner did. So the petitioner clearly indicated at the post-conviction hearing that he never received a 10-year probationary offer. Counsel, I would submit that he never really received that offer because, one, it wasn't communicated properly, obviously, because anyone would have taken a 10-year probationary sentence over what's happened now. But let's submit that through the interpreter and the lack of ability to understand English, that he never really received that offer. The other issue that the state on number F, counsel was ineffective by failing to ensure that the court instructed the jury on a lesser included offense. It's conceded that child abuse was a lesser included offense by statute of any sex crimes. And during the trial, the state actually was leaning towards going ahead and allowing the child abuse lesser included. However, when the trial court asked the trial counsel, he didn't ask for it. We would submit that that's deficient. There was no reason why he shouldn't have asked for a child abuse lesser included offense when it was available and legally should have been given, and that was deficient. and we would submit that it was prejudicial because it didn't allow for the jury to have an alternative theory of what happened. Because the reality is that there was no witnesses to any of these allegations. It was only the alleged victim's testimony mainly that was testifying, and she claimed that no one was around during these allegations. And so the jury could reasonably have ruled that she was abused, but not sexually abused, as when she had a forensic exam, she was experiencing pain. I'm sorry, I thought I heard somebody. So we would submit that number F, trial counsel was deficient and it prejudiced the petitioner by not having the lesser included offense. And the allegation number 6, trial counsel was ineffective about failing to mount a credible defense and strategy for trial. This goes to the fact that he didn't ask for a bill of particulars, and he never called any witnesses, and he didn't really mount any defense other than cross-examination. And quite frankly, the brother lived in the house during the second house that they lived in. The brother was potentially a perpetrator. The brother also lived in the same town as the petitioner. The petitioner could have had other witnesses if it was narrowed down to whether they saw any indications of after effects of sexual abuse. What was the demeanor of the alleged victim? Was she frightful of the petitioner? None of these witnesses were ever provided by the trial counsel. We would submit that based on that, the fact that there was really no strategy other than just cross-examination, that the petitioner should be granted a new trial. And then that goes to allegation number G, that the cumulative effect of all these would require that a new trial be granted. Now, certainly, the cumulative effect, even though the deficiencies individually might not be prejudicial, the cumulative effect can render it to be prejudicial. We would submit the fact that trial counsel never asked for a bill of particulars, which never was provided him an adequate ability to defend the petitioner by narrowing down the time frames. The fact that he never asked for a lesser included offense that was offered by statute. The fact that he really didn't mount any defense at all. That he never called any witnesses other than the petitioner, and trial counsel admitted that he never prepared the petitioner for trial to testify. And so that was a surprise to trial counsel. The petitioner wanted to testify, but at the same time, there was no defense witnesses or anyone or any alternative theories other than just sheer cross-examination. We would submit that based on all that, petitioner should be provided a new trial. And I forgot to mention that I was going to reserve time for rebuttal, and I apologize for that.
You have 5 minutes.
5 minutes for rebuttal?
Yes. Okay.
Do your honors have any questions?
Mr. Turner, I have a question, and it pertains to your statement about the offer of a 10-year probationary sentence. Did the petitioner testify at the post-conviction hearing that he was not aware of that offer, and that had he been made aware of it, he would have pled guilty and accepted that offer?
Your Honor, he testified that he was not aware of the offer, but I don't believe he testified to the second part.
All right. So the language difficulty is the evidence of that would have come from the testimony of the counsel who represented him at the time. I'm just wondering, obviously it's concerning if you think that, an important matter was not conveyed to the petitioner or was conveyed to him in a language that he did not understand. I'm just wondering, where did that evidence come from? Did the petitioner testify that his English skills were lacking to the point that he could not understand some of the advice his attorney gave him?
No, the petitioner testified specifically that he never received a 10-year probationary offer, that all the offers were for sentence to serve. The trial counsel testified that he did offer the 10-year probationary offer, and I believe he wrote it on a notepad, a yellow notepad, which was his mode of operation, that he would carry a notepad and convey it like that. There was no testimony at the post-conviction hearing specifically about whether or not the Spanish was an issue with the petitioner. It was, but there was evidence by the trial counsel that said that he had difficulty. He wasn't fluent in Spanish, so he would have another lawyer there who did speak some Spanish. However, the other lawyer never testified, and they never testified exactly what was written on the pad, but it was assumed through the testimony that he was writing in English what the offer was. And so the disconcerting part is there was no testimony at the post-conviction hearing from the other lawyer about what he communicated to the petitioner. The petitioner obviously has a language barrier because he had an interpreter at the trial and at the post-conviction hearing. And certainly if you're going to convey a 10-year probationary offer, then that needs to be made sure that that was communicated correctly. And there was really no evidence at the trial from the trial counsel that he really did communicate it correctly. It was very.
Was there evidence that your client could not read or write English language?
No, Your Honor. It was. I'm just inferring from the fact that he had an interpreter at both at the trial and the hearing, and that the trial counsel used another lawyer to communicate with them because he didn't understand English very well. So trial counsel conceded basically that there was an English language barrier.
Are you aware of the standard of proof that you're required to show to get post-conviction relief?
Yes, I'm aware, Your Honor. I have to show one is deficient by a reasonable objective standard and that it prejudiced the petitioner.
And you've got to do that by clear and convincing evidence?
Yes.
Okay. By the way, I'll go ahead and throw this one in for you. I got away from this a long time ago, but there is a case out there that is just, if you do any post-conviction work and you're not aware of it, it is the quintessential case that absolutely guts most cases and does not allow you relief. And that's State versus Black, written by one of my colleagues a long time ago, presiding judge Joe B. Jones from Memphis, Tennessee. And it just simply states that if you don't call the witnesses, you're out. So we can't complain about, you never win a post-conviction case complaining that a trial lawyer didn't call the witnesses that you yourself don't call. Just for thought, put that in your education folder today.
Thank you. I understand, Your Honor. I did not do the post-conviction hearing. I've just done the appeal.
We understand that too. We sure that puts you in a distinct disadvantage, and you've done well so far. Any questions from the court? Let's hear from the state.
Thank you, Your Honor.
May it please the court, Brent Sherry for the state. I'll jump right into the arguments that the petitioner is presenting here today. First of all, failing to interview and call witnesses, as Judge Williams has already very eloquently noted. In order to find that the petitioner is entitled to relief on this claim, there has to be something on the record about what the missing witnesses would have testified to. And here, of course, the petitioner had no witnesses that appeared at the post-conviction hearing, neither people who lived at the house, nor an expert to testify about this is what I would have said had I been called to testify at trial. So that pretty much covers the first two claims here of failing to call and interview witnesses and failing to employ a forensic psychologist to talk about sexual abuse allegations. On the third argument, the petitioner complains that counsel failed to call witnesses again that would have clearly rebutted that there were any signs of sexual abuse between the petitioner and the victim. And again, no witnesses appeared at the post-conviction hearing to address that claim. Then the petitioner argues that Mr. Himmelberg never offered any evidence as to another perpetrator, given that the DNA implicated any number of persons from the petitioner's lineage. What the DNA expert testified to at trial was that there was not enough DNA taken from this little girl's vaginal area to conclusively determine that the petitioner was the contributor of this semen. However, they did have enough DNA material to determine that the semen came from someone in the petitioner's paternal lineage, meaning it had to come through the father or it could have been a brother. When we address that issue, Mr. Himmelberg testified that his team interviewed both the petitioner's brother and his father, who were the only other two possibilities as contributors here for the sperm that was found in the girl's vaginal area. Mr. Himmelberg testified that the brother was not around during that time frame and the father wasn't even in the same state. And if we go back to the trial testimony of the petitioner, he testified kind of as a surprise. Mr. Himmelberg testified at the post-conviction hearing that they didn't expect that the petitioner was going to testify at trial, and at the last minute, the petitioner wanted to testify, and he did. And he claimed in his testimony that, of course, he had never abused this child. On cross-examination, he was confronted with the DNA evidence and asked about his brothers, and at that point, he conceded that neither of them had been in the area to be able to contribute this semen. And again, this was at the end of this period of abuse in May of 2009. And shortly after this little girl divulged the information to a school counselor, she was taken to the Our Kids Center, and a physical examination was done, and semen was found on her. So Judge Dozier determined that in this case, that Mr. Himmelberg was not deficient, and there was no prejudice. As far as failure to communicate with the petitioner complains that Mr. Himmelberg should have communicated more with him about the facts of his case and possible defenses. He complains that Mr. Himmelberg only visited him once at the trial and then only spoke with him when there were court appearances. Mr. Himmelberg testified that he visited him on a couple of different occasions and testified that he brought another attorney with him on many of those occasions who was fluent in Spanish to make sure that things were communicated properly. When in Judge Dozier's order denying relief, he noted that while the petitioner complained that Mr. Himmelberg never visited him at trial, he conceded during his cross-examination that he had at least 2 visits at the jail, in addition to speaking with Mr. Himmelberg and Mr. Merrill, the other attorney, at his court dates. Again, Mr. Himmelberg testified that he met with the petitioner and discussed the case, laying out the petitioner's exposure and explaining the best and worst case scenarios. He testified that he spoke with the petitioner extensively about the facts of the case and tried to determine why the victim would make up her claims. Mr. Himmelberg testified that he discussed the DNA problem with the petitioner and presented him with a 10-year probation offer from the state, but the petitioner rejected it. Just my recollection from the testimony at the post-conviction hearing, I don't recall that there was testimony specifically about whether the other attorney, Mr. Merrill, was with Mr. Himmelberg at that point. and he wasn't challenged about any language barriers at that stage. But his testimony was that he presented the 10-year probation officer to the petitioner, and the petitioner rejected it. And just to put this in a proper context, I think it's important to recognize that when he presented this 10-year probation offer, this was prior to getting the DNA results back in this case. So at that stage, as far as the petitioner knew, the only real evidence against him was the testimony of his child. So he rejected the 10-year probation offer, and then the DNA came back, establishing that the semen had come from somebody in the petitioner's paternal lineage, meaning through his father's bloodline. And at that point, he was in big trouble. As far as the failure to file a motion for a bill of particulars, the petitioner argues that Mr. Himmelberg should have filed a motion for such a bill of particulars, and he complains that he never had notice of the exact dates of the allegations in the indictment. But when you look at this case, as is the case in many child sex cases, the child didn't give any specific dates for when these offenses took place. Her references were to I was about 5 years old, or I lived in a house on whatever street it was. There were several different locations that were stated during her testimony. And it's important also to recognize that in this case, as in many cases, the child sat down with a forensic interviewer, and that interview was recorded. And there's no claim that the petitioner was not given discovery, that did not have access to the child's statements or to the interview or anything else. Everything was there for the petitioner to access and see what the testimony of this child would have been, what the evidence would have been. In child sex cases, again, as this court is well aware, the state is required to make an election of offenses after the presentation of evidence. At that point, the state can choose and determine which offenses are established by which facts that have been presented. And that happened in this case. And I think that's all been laid out in the brief, exactly what happened. It's as far as deficiency, should have Mr. Himmelberg filed a motion for a bill of particulars. He wasn't asked, when he was asked about this at the PC hearing, he didn't recall whether he had filed one or not. But when you really look at this case, the bill of particulars, as I noted in my brief, is not a discovery device. Of course, we want to give the petitioner the opportunity to trial, and he had all the evidence and all the discovery to be able to do that. So we really can't say that there was any prejudice here, because the defendant had all the materials, had all the discovery, was aware of what the child would testify to and what he would have to defend against. As far as the lesser included offenses are concerned, if the court were to go back and look at the election of offenses and the testimony of the child, there wasn't any testimony about any pain on any of these occasions when the petitioner committed these acts of abuse. When the child met with the forensic interviewer, she was asked if there was any pain that resulted from the petitioner's abuse. And she, referring to the times when the petitioner touched her, the child said, and I may not have this word for word correct, but in essence, she told the forensic interviewer that it hurt sometimes when he rubbed her down there a lot. So that doesn't go to any specific or any singular identifiable act that was covered in the election of offenses, but it was referring to a pattern of abuse that occurred over those several years. In any event, when the trial court instructed the jury, one lesser included offense that was given was I'm sorry, I've kind of lost my train here just a little bit, but it was assault by offensive touching. Now, assault by offensive touching is I believe that's a Class B misdemeanor. And if we talk about child abuse, and of course, talking about the infliction of pain, that's a Class D felony. So if we're talking about the difference between these offenses, in order to find the petitioner guilty of child abuse, basically we're taking out the element of sexual intent or sexual touching, and then we're putting in an element of pain. I wish this was just a strict Blockberger kind of analysis, but of course we don't do that in this type of a case. But if you take out the child abuse offense, and we look at this, and we look at the assault by offensive touching is essentially the same as a sexual assault if you take out the sexual portion. So for the petitioner to argue that the jury could have found him guilty of child abuse, essentially they would have had to reject the child's claim of a sexual touching and yet find him guilty of a touching. And that's what we have when we go to the assault by offensive touching. The bottom line here is that it's not even reasonable when you look at the testimony of the child, you look at the findings of the court, that the jury would have found this defendant guilty of child abuse and rejected the greater offenses of child rape and aggravated child sexual assault. So the petitioner is just simply not entitled to relief there. I believe the last claim here has to do with the cumulative effect of the petitioner's or of counsel's deficient representation. And it's hard to see any real deficiency that the counsel committed in this case. He had a difficult case to try, especially after the DNA results came back. The best he could do is try to cast doubt on the child's testimony, and he did that every way that he could. He did not present evidence that would not help the defendant's case, the petitioner's case, and his representation was simply the best he could do under the circumstances with the facts that were presented. With that, the state would suggest that the petitioner has failed to prove by clear and convincing evidence that he's entitled to any relief here, and that the decision of the post-conviction court should stand. There are no questions. Again, the state would ask the court to affirm the post-conviction court.
Seeing no questions, we'll continue with the rebuttal.
Thank you, Your Honor. I'll be brief. One point that the state made was about the DNA and trial counsel interviewing witnesses, and the state alleged, rightfully so, that trial counsel said that he had interviewed the brother and that the brother wasn't around. However, that statement is clearly false because it's undisputed that the brother lived in the same household of the petitioner and the alleged victim, and the brother was around when the mother confronted the petitioner about the alleged incident. So that statement clearly on the record doesn't hold any merit. We would submit that the trial counsel should have looked to the brother as an alternative theory of what happened. As far as a failure to communicate, the state does concede that there was no testimony about whether Mr. Merrill was present during the alleged offer. However, it is undisputed the fact that obviously the trial counsel was using Mr. Merrill as an interpreter, and if the offer was conveyed and it wasn't communicated properly, as the petitioner testified that he never received a 10-year probationary offer, that should be grounded as a deficient and it prejudiced the defendant, because obviously he's got way more time than that. As far as the bill of particulars, the state's main point is about the child didn't allege specific dates. Well, that's not really the law. The law is pretty clear that the state needs to provide, in Hicks, that they need to provide some sort of time frames and something a little bit more narrow than 3.5 years to prepare for trial. And the state v. Hicks clearly said that the failure for the trial judge to grant a bill of particulars about the times and dates around a 1-year sex abuse allegations was reversible error, and they granted a new trial. And we would submit that this is a major deficiency in trial counsel. It was conceded that it was deficient and did prejudice them because it was unable to really present a defense. And so with that, I'll just conclude all the arguments, Your Honor, and ask that the petitioners be granted a new trial. And that's all we have. Thanks, Judge.
Mr. Turner, I just wanted to comment that I understand that you did not represent the petitioner at the post-conviction hearing, and I just wanted to express the court's appreciation to you for accepting the appointment and handling this case on appeal. And you've done an excellent job, and as has General Cherry, as always. But I just want you to know we appreciate having good attorneys. Oftentimes, we might wonder how things might have gone had you been able to represent him at the PC hearing. But anyway, we appreciate it. Thank you.
Thank you, Your Honor.
Judge Holloway, anything from you today?
Nope, good job, both counsel.
Mr. Turner, welcome to the Tennessee Court of Criminal Appeals. How did it feel today?
It's a little daunting on the computer. I've appeared in person a couple of times, but just being on a computer is a little daunting, I gotta admit, Your Honor.
Are we more or less intimidating online than we are in person?
No, it's just more of not being present, Your Honor. Just like you're looking at a TV monitor, and it's just kind of bizarre.
Well, as I've stated, we would prefer to be in person, but this is seemingly, I'll ask Mr. Cherry, General Cherry, pretty good alternative, I guess, given the circumstances. We like to hear from you.
Well, Your Honor, you can see I'm right here in the courtroom.
I understand. And we are seeing more views of our arguments than we ever have had in person. The other day, there's two things bad about Zoom arguments. One is the whole world can watch you. That's the good part. And the bad part is the whole world can watch you. We have to be on our toes every day. We have to be professional every day. I hope we are. I know the lawyers that appear in front of us have to do a little extra work, and we appreciate that. I thanked you at the very beginning. But we're trying our best to do our small part in stopping the spread of COVID and keeping us from moving around. We're allowing great access to our courts. I never became a judge to ever be on YouTube, I can tell you that, but here I am. And it seems to allow other people access to us. The clients can see it after. They can even review it again. You can look at it tomorrow and maybe sharpen an argument for the next case you have. We allow call-in numbers too, where folks that don't have computers can get access to the video, audio of what we say, and providing the citizens with the greatest access to the courts that's ever been known. If that's what comes out of this pandemic, it may be a worthy thing that we've done. So we try, and thank you both for a very well presented argument today. We'll ask the Supreme Court Clerk, Jim Hibner, to come back and adjourn us to call the next case.